Hello, good afternoon, and welcome to The Law. This is your Legal Light. This is your Help Law. On July 5, 2025, the Circuit Court here in Accra convicted Patricia Esiedua, popularly known as Agradaa, to 15 years, convicted and sentenced her to 15 years in prison. 15 years on 2 counts of defrauding by false pretenses, and 1 year for charlatanic advertisements with a fine in default to pay. This week, she was very successful at appealing the decision. She made a victory on the sentence, but not on the conviction itself. The High Court, sitting in Amasaman, said the Circuit Court did no wrong. She, in fact, was guilty of the offenses she was charged. But the sentence, 15 years, was too harsh. So the court has reduced that to 1 year. In prison calculation terms, she should be out of jail in the next 2-3 months. But that judgment is the subject of our review this afternoon. We're doing a surgical legal operation, and in the process to assist you to understand that when you are convicted and sentenced to jail, there is always an opportunity to appeal to the court to have the sentence reduced. How do you go about that? We have 3 lawyers, including the lawyer who led this process, right here in the studio. There is also a new legal reform bill, legal education reform bill. In 2019, all the law students in Ghana who qualified to sit for exams to go to the law school so they can qualify to practice as lawyers sat the exams. And guess what? Over 90% failed that exam. It doesn't matter that some had first class from their law faculties. They failed. They couldn't progress. In 2021, over 70% of the number failed that exams. So they have law degrees, but they couldn't progress to become lawyers. In 2023, over 60% failed that exams. Now, this has pushed for the legal education reform bill, scrapping the current situation where you have to sit for exams and going through the process at your university where you are being educated for the LLB to get a practicing certificate. How is that going to look like? We'll be right back. You're welcome back. This is The Law. It's your Legal Light. It is your Help Law. And we're dealing with 2 very important topics. In fact, I have been advised that we are unable to treat the 2 topics at one go. But we will attempt. Perhaps there will be the part 2 where we will be able to complete, particularly the second topic about the legal education bill. My guests, a man you have been very familiar with on this platform, Daniel Korang, partner Adum Legal Consults and author of several legal texts, particularly criminal law. Daniel, thanks very much for making time to join us.
Thank you very much, Samson, for having me. And
Great.
Good afternoon.
Good afternoon. I'm excited that your sound is so clear this afternoon. Daniel reaches us from all the way in his Sunyani where he loves to be, and often the line is not that great, but today is so good. Gertrude Amako Ama is lecturer, UPSA Law School, and senior associate Osudapa Law and Associate. Gertrude, thanks for making time to join us.
Good afternoon, Senior. Thank you so much for having me.
We have been chasing you to be here for a while.
Finally.
Okay. Also right here is a man who is in a celebratory mode. I don't know today if he was in Agrada's church. The lawyers don't often do that. So Richard Asarebafo is lawyer for evangelist Patricia Asiama, popularly known as Agradaa. Rich, thanks for joining us.
Good afternoon, Samson. Thank you very much for having me.
Great. All right, so first things first, let's begin with Rich. And let me post this caveat. I posted it on Newsfile yesterday, but I need to repeat it. If you were thinking that this is Samson's Take, no. Samson's Take is completely a different ball game. When I sit here, we deal with the law pure and simple. That's all we're going to do about, and it's not about my opinions at all. So let's get ready for this. Now, I'm going to read the very first page of the judgment of the High Court and bring you in. The judgment as delivered by His Lordship Solomon upon Chumesi on Thursday, the 5th day of February 2026, in the matter of Patricia Esiedua, the appellant, versus the Republic. The first page reads, on 5th July 2025, the appellant herein was convicted by the Circuit Court, Accra, on account of charlatanic advertisements in newspapers contrary to Section 137 of the Criminal and Other Offences Act 1960, Act 29. The appellant was also convicted on 2 counts of defrauding by false pretenses contrary to Section 131(1) of the same Criminal and Other Offences Act 1960, Act 29. And she was subsequently and consequently sentenced to a fine of 25 penalty units, or in default, 30 days imprisonment. Okay, so actually the first offense, 30 days imprisonment. Earlier I said 1 year. 30 days imprisonment on count 1, and 15 years imprisonment in hard labor on the other 2 counts. That is defrauding by false pretenses, with all sentences to run concurrently. That is to say, the appellant was to serve 15 years in hard labor in all. And this is what brought about the appeal. What did you tell the court you were unhappy with that it needed to change? And how do you appreciate the outcome?
Okay, so generally it's a mixed feeling. The address that we filed was about 48 pages. We dedicated 43 to pointing out to certain facts and then procedural flaws, which we thought on those bases, the conviction itself should be set aside. So our primary objective was to get the conviction set aside. The judge listened to us and his opinion and his view. He felt it is proper for him to uphold the conviction and rather to give us a substantial reduction of 1 year. And at times, I appreciate the concerns we are expressing about the judgment. But if you take Patricia Esiedua off the discussion, and you are told that someone defrauded another person in the sum of 500 Ghana cedis, and that person is to be punished, I'm sure we should be talking about a month or 2. So even but for the fact that it is Patricia Esiedua, the 1 year term still would have been harsh and excessive under the circumstance.
So first, you wanted the conviction
very well
set aside.
Set aside.
And second, you wanted, of course, once the conviction had been set aside,
obviously,
we will not talk about the sentence, but you went on 2 grounds.
Very well.
Set aside the conviction or reduce the sentence of 15 years.
That's correct.
The judge said the conviction cannot be set aside.
Very well.
Because he was found guilty.
Sure.
And he also, in his evaluation of the evidence, confirmed that she, in fact, did the thing she did.
Yes.
So he can't set it aside.
Yes.
But the sentence, he said, it was a case of using the sledgehammer on a mosquito.
That is also a narrative out there. But I'm happy this is a legal platform.
Right.
And as lawyers, we know that in any judgment, there is an arbiter. And then there is the other side, the arbiter and
That decisis.
The ratio.
The ratio.
ratio. Yes. So the court did not premise its decision on that thing. It's just something that it was an analogy that he drew. He discussed the law extensively, made references to the case of Salome, and even referenced the amount involved in that case and the punishment that came with it. So he was like, if in Salome's case, the amount involved was over 1 million Ghana cedis and was given 8 years, then how then do we justify a fraud involving 500 Ghana cedis? You see, if you look at the reasoning of the circuit court, I think all this while we were made to believe that in the offense of fraud by false pretenses, the minimum punishment is 10 years and the maximum is 25 years. I have looked at the Parent Act time and again. That is not in the Act. If you look at Section 131 of the Act 29,
There's no minimum. It says where the penalty has not been prescribed.
Yes.
The maximum should be 10 years.
Yes.
That is in the Parent Act.
Yes.
But you know that by the different amendments that have happened, including recently, defaulting by false pretenses, the maximum is now 25 years.
Yes.
Right.
But that's the impression the circuit court judge made us believe. In fact, she said that if you look at her judgment critically, she made reference to the sentencing guideline. Of course, the sentencing guideline is an inferior thing. You can't use it to regulate the Parent Act. The Parent Act did not make any minimum punishment. Even with the sentencing guideline, it provides 3 steps. The first thing you should look at is the amount involved. Then if you look at that, you look at other aggravating and mitigating factor. Then it gave us 5 levels. On the first level is between 0 to 500 penalty units. You're able to go non-custodial. 500 penalty units, Samson, is just about 6,000 cedis. So if the amount involved is 6,000 Ghana cedis, you can give non-custodial sentence. Unless there are other aggravating factors, then it moves you to the level 2. That will admit the person to 0 to 2 years. Then you go to the level 3, between 500 penalty units to 5,000 penalty units. That's about 6,000 to 60,000. Even with 60,000, you are good to go about 5 years maximum. So if you look at level 4 and level 5, they never envisaged a situation where the amount would be 500 Ghana cedis and you to fix the person at the highest band. That will admit you to 10 to 25 years and for you to impose that 15 years. So clearly, the circuit court judge got it wrong there and it had to be corrected, and which the High Court judge did. And we believe that, you see, the judge gave a tone for his judgment at page 9. He said he was not going to pay attention to all the technical flaws because it is a criminal case, and a criminal case ought not to turn on technicalities. That I agree with, but I believe there was a second leg. If the technicalities we are complaining about lead to substantial miscarriage of justice, justice is not just about substantive justice, it's also about procedural justice. So where there are procedural flaws and we appointed them to you, and you believe that it had occasioned substantial miscarriage of justice, I believe the appellate court shouldn't have closed its eyes to the technical procedural flaws that we pointed out.
Did the judge say he was going to close his eyes to technical flaws, in fact? Or he was saying that you, in your writing or your grounds of appeal, you have used language that is not known, like you use petitioner, where you are supposed to use the appellant. You use accused, and he says those you are not supposed to use. And even formulating the grounds, he says that the traditional way of formulating the grounds, which you didn't use. And he says, I'm not going to pay attention to those things. Am I right? That is what he said he's not going to pay attention to, or that there was technical issues with the judgment itself that he wasn't going to pay attention to.
I will not debate you on that, but at least it gets us to the mind of the judge. That this is a criminal case.
Right.
And I'm not going to pay attention to technical matters. I'm swayed by what the Supreme Court have said. and I'm going to look at the substantive matter. Okay. So at least it gives us the tone. And for us to understand why the judge did not comment even on all the procedural flaws that we highlighted in the first 43 pages of our appeal.
No, I was mentioning that for accuracy.
Yes.
So that we don't put the judge in the wrong light.
Sure.
The judge complained about certain things.
Yes.
They were not about the judgment, in fact. Even though in the judgment he had certain issues with the prosecution and a few things. But the earlier thing I mentioned, I suppose that is what he said he wasn't going to pay attention to. Okay. Now, let me get to Daniel. So, Daniel, what's your reading of how the judge came to the conclusions he did?
Thank you very much, Samson. And good afternoon to your cherished viewers. In criminal law and practice, it is always said that the prosecution has the onus or the obligation to prove the guilt of anyone that is accused to have committed a crime, and that the accused person bears no such onus or responsibility. Now, when you read the appellate judgment, that is the judgment of the High Court, the court found that the guilt of the appellant was well established beyond reasonable doubt. And looking at the evidence before the trial court, it was clear that the appellant committed the offense. My reading of the two judgments, the judgment of the trial court and that of the appellate court, reveals that the appellant, in my candid opinion, was guilty of the offenses charged. The evidence placed before the court was sufficient, adequate, and convincing enough, at least from my understanding of the law. And so I do not find that there was any miscarriage of justice by convicting the appellant. I mean, that is at the trial stage. And I also agree perfectly with the appellate judge that the trial court did no wrong by convicting the appellant. Now, coming to the sentence reduction, if I may go there now.
Hold on, Daniel. So that we carry our audience along with us, when the High Court judge says he affirms or confirms the decision of the Circuit Court that, in fact, the offenses were committed, there are things that he points us to. I want to just read one or two so that we all may be on the same page. He says that the video was an advert made towards the 7th October all-night service. So the video did not include the activities of the all-night service. The investigation caution statement of the appellant, that is Agradaa, herself, Exhibit D, left no reasonable mind in doubt to find the existence of the fact that Agradaa indeed committed the offense of charlatanic advertisement. Again, reference is made to Section 11(1) of the Evidence Act. Agradaa herself admitted that she ran the said advertisement in which she announced that she was going to give away a whopping sum of 300,000 Ghana cedis because October was her birth month. So this is the first charge of charlatanic advertisement. And you were trying to show that that has not been proved beyond doubt. And the judge said it has actually been proved beyond doubt because she herself has admitted that she made that advertisement to people that on her birth month, on the 7th, when they come to church, he was going to give out 300,000 Ghana cedis. So that one, there's no doubt about it. And then on the basis of that, there are other portions of the judgment where the judge comes to confirm that at least there are two people. Even though many people were in church, on the back of that advertisement, George Boateng, Samuel Ampadu, and George Boateng were the ones who came forward to make the complaint that they brought their monies and the money was not doubled as was promised. Correct?
Yes.
Okay. Please, go ahead.
But if I may.
Yes. Okay. Hold on, Daniel.
Okay, so you made reference to some exhibits that were tendered. That is what the appellate courts is making reference to.
That's right.
And I made the point earlier that we had pointed the appellate court to several procedural flaws.
Okay.
In the course of the trial, the charge sheet was amended 2 times. And any time a charge sheet is amended and it is withdrawn, the previous proceedings comes on its knees, so that the case must be started de novo. So that if you have tendered evidence earlier and you amend it and you are restarting it, that evidence must come back again into the record. So technically speaking, though these things were tendered, that's why they just said, I'm not going to turn on technicalities. So though they presented it, but technically, if we were to give the law straight interpretation of it, then you can argue that they presented it, but they never found its way to in the evidence properly so-called, because the charge sheet had been withdrawn. And there are several authorities to that. The charge sheet had been withdrawn, a new one is brought. Prosecution ought to have brought back the witnesses, retendered the witness statements, so that cross-examination can now continue. If you fail to do that, we said, yes, it shouldn't have been in evidence.
Okay. So those were some of the technicalities that you are concerned about. Now, before Daniel continues, let's watch this. I think it is what the courts, both courts were talking about.
Where so eka ho a where so 1 billion. It's a ushe sika egu hayi na. Osofo fabra form kakra. Osofo fafon ne bra form. Fafon ne bra form. Fafon ne bra form. Good. It's a ushe sika ya egu hayi a. Not to say a 3 billion cedis. 3 billion. Aska we nyina no. Ya de ko asoli fie ho ewrade ya domu a efie da eda ya nimu on the 7th of October enumere 7 o'clock na ya share all night na say ye ko check asofo we de wo de to so good ye ko check e de ama dwadifo emakuofo obabia asofo manemra from be say Toscan so e ko form good. It's always kebu na 3 billion. I dey heavyweight champion Pedamosaka Krosofo international ministry.
All right. So for those of you who don't have the benefit of Chi, all she was saying was demonstrating and displaying that that money was a total of 300,000, and the all night to which she was inviting people to attend, that money will be giving out to people. And they were invited to come and pay X amount, and they will be giving the money. Now, Daniel, before you continue, Richard just made a comment that one of the technicalities that they raised was that the charge sheet was amended 2 times.
Yes.
And he's saying that at any stage, when the charge sheet is amended, the trial must start de novo. It must start all over again. Please, have you written about that in any of your criminal law books?
In fact, it's this authority that I used.
Yes, Daniel.
All right, thank you very much. Now, it is not entirely correct to say that whenever a charge sheet is amended, the trial at whatever stage it is must restart. It depends on the kind of amendment. Now, the prosecutor might just omit a word, just a word, in the charge sheet, and upon detection, the prosecutor might tell the court that, oh, my lord, I didn't include the article de or article e. And so to make it grammatically right or correct, I seek leave to use pen to do this correction. That is also an amendment, but that will certainly not bring the case back to start. Now, the amendment that gets a case to restart afresh is where the amendment goes to the ingredients of the offense being charged, so that the first charge sheet would have to be withdrawn and substituted.
Thank you very much.
Lower of a charge sheet and a substitution of a new one.
Thank you.
It means that the basis of the entire trial has now, fallen flat, and so we have to restart the case.
Right. So please go to your issue of the sentencing and whether or not what your comments are about it.
Thank you very much. I think that I would not also criticize or fault the appellate judge for reducing the sentence from 15 to 1 year. You see, sometimes when you have a case like that of Agradaa flying on social media, it is very difficult to maintain a candid position of the law, because already the person has been tried, convicted, and sentenced in social media. And so when you are, talking law, it is not everybody who will agree with you. Now, let me mention that sentencing at every stage of a criminal trial is a judicial exercise that is regulated by law. Sentencing is a judicial exercise regulated by law. Sentencing is never a function of lottery. Nobody ever cut, lots or lottery to pronounce a sentence. At every stage of the sentencing process, the judge must be guided by law, by practice, and by procedure. Now, when you look at sentencing as jurisprudence, we say that before a judge imposes a sentence, the judge would have to consider mitigating factors and aggravating factors.
Yes, Richard had mentioned that, yeah.
When we say mitigating factors, they are the factors or the considerations that will help to reduce the sentence. And the aggravating factors, on the other hand, are those that would help the judge to say, I am giving you a very harsh sentence because of A and B and C.
Right.
Now, let's look at some examples of mitigating factors. One, that the accused person is a first offender, somebody who has had his or her first brush with the law. So that if you are a first person, if you are the first time you are being convicted.
Please run through them fast, because we have gone over them on this show with you over and again. Well. Yes, so run through them fast.
You are just a first offender. You have just committed a criminal offense for the first time. In this case, Agradaa was a first offender, as far as the records show. The second is that offenses involving fraud, like Agrada's own, that involved money, the amount is just small. You see, when we have fraud that involves huge amounts, the highness or the amount involved will automatically translate into an aggravating factor. So when you have somebody defrauding two people to the tune of 1,000 Ghana cedis, certainly the amount is too small to give the person a high sentence.
But in this case, the circuit court judge took into consideration the entire circumstance. Even though two people are those who make the complaint, there was a crowd, and there are videos that show the crowd and the complaints about those who were victims, except only two people came forward.
Samson, I think that it is a very important consideration, but if the circuit court judge was, persuaded by that video, then she certainly relied on extrajudicial material. She relied on material that were not before her. When somebody is alleged to have defrauded 100 people in a video, and only one person comes forward, and that person's evidence is placed before the court, the judge has no business considering the evidence of those who did not come before her.
Richard just said that the judge said he was not going to focus on technicalities, but to do substantial justice. And in fact, he quotes Supreme Court authorities to pay attention to the substance rather than the technicalities. Is it not technicalities you are paying attention to here?
Never. You see, in criminal trial, in punishing a person, we must ensure that we base the punishment on the right material before the court.
Right.
So when you tell me that over 1,000 people were seen in the video and only 2 came forward, to do substantial justice, you can never rely on the fact and the circumstances of those who did not come before the court. That is why I agree with the appellate court that given the circumstances of this case, as far as the evidence is concerned, the amount involved was just 1,000. And the appellate court judge said that he was not trying to say that only 1,000 was not enough to punish her. But we know the principle of considering the gravity of the offense.
Right.
You know, the amount involved went to the gravity of it. And so I think the judge was right in reducing the sentence, because if it had not been a personality like Agradaa and it had been any other street person, would the person have gone to 15 years for defrauding somebody to the tune of 1,000? Certainly no. And so I think that if you consider the amount involved, then...
but as we know, every case is done on case-by-case basis. So the individual's exposure and opportunity should also be taken into account, shouldn't it? If it was an ordinary person, it's an ordinary person, but it is somebody who has the access of a media platform by herself. She has a TV station, and she's doing these things.
Now, something you would also read from the High Court judge's judgment that he said Agradaa is an evangelist or a pastor who is supposed to know better. You see, so the status of the appellant was an aggravating factor. And that is why the judge agreed that she should not be spared custodial sentence altogether, but 1 year will be enough.
Please hold on. Let's bring in Gertrude. Gertrude.
Yes.
Yes, what's your evaluation of this sentence reduction?
Well, thank you, Samson. It's been interesting listening to my 2 colleagues here. Of course, for counsel here, it's a good time to say congratulations again.
Right.
I think they have done a good job. This is the dream of every lawyer, isn't it? To be able to secure the wishes of their client. So kudos on that.
Thank you.
I have listened keenly.
In this case, they may have exceeded the wishes.
Well, even better for them, isn't it? I have keenly listened to the submissions of Daniel, particularly on the issue of sentencing. Not to belabor the point, but the appeal was based on, in my opinion, 2 major grounds: seeking to overturn the conviction itself, and then seeking to, have a reduction of the sentence. Unfortunately, the first was not very successful, not successful at all. But the second, they failed. The second, they had a massive win over them. I want to pick up from where Daniel left off, and perhaps to say that let us take a step back to look at the legal underpinnings of punishment generally. Why is it that when someone commits a crime specifically, or when someone does a wrong, it is important for that person to be punished? And I'm sure we are all quite familiar with the various theories of punishment that we have in criminal law. Generally, it's either we are looking at the retributivist theories or the utilitarian approaches. So under the retributive approach, we are simply saying that, look, people need to be punished for the wrongs that they do. That is a classic retributive theory, an eye for an eye. On the other hand, it is important that the punishment that we met out to wrongdoers fits the crime that they have been convicted of. Okay? So that's one leg. Of course, for the utilitarianists, they believe that, look, let's go beyond merely punishing the person involved, and let's look at the greater good of the punishment that is going to be meted out to that person. Why am I saying that? I'm saying all this because beyond the strict black and white letters of the law, I believe that it's important for us to also look at the underpinnings of the law, including the reasons why sentencing or the grounds on which a court, an appellate court in this case, would reduce a particular sentence that has been awarded by a trial court. So, in fact, when you look at our legal system, I strongly believe that we have a mixture of the two, because punishment seeks to, sentencing or punishment generally seeks to punish people who have done wrongs, while at the same time to be able to serve as a deterrent or to even ensure that by the time that they have served that punishment, they would have been reformed in one way or the other. Flowing from that, I think we are all on the same level to a large extent on the refusal of the appellate court to overturn the convictions. But the controversy, as it were, has to do with the sentencing or the reduction of the sentence. Now, this, like Daniel rightly said, in as much as the ability or the power of an appellate court to reduce a given sentence of a trial court is discretional, that discretion ought to be confined or bordered by the dictates of the law itself, and in some cases, practice. For me, I don't know the lady in question anywhere. I don't follow her on social media. I've heard a few things being said about her, but I try to evaluate the current case on the basis of the four corners of the case and nothing more. I found it a bit baffling, the what I would call a discrepancy between the analysis of the judge in holding that the convictions are right, are lawful. However, in the exercise of his discretion, the sentence ought to be reduced from 15 years to 1 year. I also believed initially that, look, 15 years is a bit, it's a bit too harsh. But a reduction of 14 years difference for an offense which is a first-degree felony.
No.
Sorry, a second-degree felony.
2 counts on second-degree felony.
Yes, and the first is...
And 1 count on a misdemeanor.
On a misdemeanor, exactly. Right. So the second-degree felony of defrauding by false pretenses. We have all said that the law does not give a minimum sentence, but a maximum of 25 years. Now, in as much as, and this is my opinion, in as much as the law does not prescribe a minimum sentence for this particular offense of defrauding by false false pretenses, I do not think that the punishment should also be one that can be equated to a misdemeanor. I think that there's a policy reason and there's a justification for the different levels of offenses that we have under our criminal laws. So I don't have a problem with a reduction in the sentence.
But Richard
not
is
at
telling
all.
you that if you consider the sentencing guidelines,
right,
then it might bring you, is that what you're saying? It might bring you to that point. You use the amount involved.
Yes.
And in this case, regardless that there were many people, there are only 2 who have shown up and have made a complaint. All the 2, if you put the money they brought together, it gives you 1,000. Let's not look at what their circumstances and what 1,000 cedis mean to them.
You see, the sentencing guidelines does not end over there. When you look at the specific considerations of the sentencing guidelines, apart from the seriousness of the offense, the victim itself also, himself or herself also has to be looked at. The accused person, the public interest, those are all considerations under the sentencing guidelines.
So the circuit court judge said that Agradaa did not show remorse, but the appellate judge disagrees with the circuit court judge.
Yes.
How is that possible for a judge who is not a trial judge to talk about matters of demeanor when you don't have the opportunity at the trial to see the accused and examine their demeanor?
Well, of course, that's a good point that you make. We all know that when it comes to issues of appeal, it is the trial court that has had the benefit of the entire circumstances of the matter, including the bodily, signals of the accused person. In fact, all other stakeholders within the process. And yes, the appeal judge or the appellate court did say that the trial court relied on three things in arriving at its conclusion. One, that the appellant's conduct was reprehensible. That's the first one. I'm talking about the trial court.
That's right.
Such offenses were prevalent in society. And the third one, which is what you just mentioned, that the appellant showed no remorse. The appeal judge agreed that, yes, the conduct involved, in his opinion, is reprehensible. It's not something that must be encouraged, and particularly given her position as a woman of God. However, like you are saying, he felt that the demonstration of remorse was evident through the mitigation that counsel had made on behalf of Madam Agradaa.
They were on their knees.
Exactly. So they had, and counsel, you were there, that you had, you had told the court about expressions of fear, sleeplessness, and you had even pleaded for a non-custodial sentence, if possible.
Yes.
So in as much as, yes, something you are right, the appeal judge did not, yes, but on the record, at least, it wasn't, the remorse was not being based on the body language, but on the record that he had before him, which had the mitigation.
So let me do this quickly and come to you, Richard, again. So like another teacher at the UPSA, Justice, who says 5 years would have been for him minimum. You say 1 year is too low. So what are you looking at? I
am saying that there are different categories of offenses under our
Yeah, we have gone over that.
Yes.
But the point that you say 1 year is too low, that the judge reduced it to a misdemeanor status. What would have been ideal? Having examined the judgment.
Now, the maximum number of years that can be given for misdemeanors is 3 years. Right. Here is a case where the offense in question is a second-degree felony.
2 counts.
2 counts of a second degree.
1 count misdemeanor.
Of a misdemeanor. Now, of course, the sentence for the misdemeanor is one that we don't have much of a challenge.
The circuit court had given 30 days.
Yes.
Plus a 25 penalty unit payment.
Yes.
Right.
Yes. But the point I'm simply making is that, look, in as much as the
for
law...
the purpose of our audiences, a penalty unit is 12 Ghana cedis.
Yeah.
So you multiply by 25.
Yeah. So the point I'm making is that even if the law fails to prescribe a minimum sentence for such a degree of an offense, which is a second-degree felony, the sentencing or the sentence, in my opinion, should not be one that is coterminous with a lower grade of an offense.
You are refusing my invitation.
I'm not refusing. What I'm saying is that if the maximum that you can give for a misdemeanor is 3 years, then for me, anything between 3 years, but definitely not 15 years. Anything between 3 years and, anything around 3 years should be fine. That way you clearly distinguish a misdemeanor from a second degree felony. You will not
be as generous a judge as Justice Solomon.
I wouldn't say so.
Right. So, from where you sit, you wanted the entire conviction to be set aside.
That's correct.
The judge comes to a conclusion, affirming the circuit courts that the conviction cannot be set aside. For example, at which page is this? He says that after a thorough examination of the evidence led by the prosecution, I came to the irresistible conclusion that the prosecution was able to prove the guilt of the appellant beyond reasonable doubt, and that indeed the appellant, that's Agradaa, on the 7th day of October 2022, defrauded the 2 complainants of various sums of monies. Accordingly, the court below was right in convicting the appellant, that's Agradaa, of the 2 counts of defrauding by false pretenses. That is after he had concluded that she was also right in convicting her on the charlatanic advertisement. Is it because you got 1 year, so you are not bothered anymore? Or since that was a grand agenda, you still take fault, that the conviction must be set aside?
Judge Solomon is a very wise judge. He's an extremely wise judge. And I tried to get into his mind. You see, he ties our hands. Because even if he had given us 2 years, he would have further appealed. Let me read paragraph, page 36 of his judgment. That's paragraph 6.0. He said, again, although, as I have found in this judgment, which finding emanated from the record of appeal and conceded by both lawyers, there were indeed some inconsistencies in the evidence of both sides, but strangely, in her judgment, the Honorable Trial Judge only commented on the inconsistencies in the evidence of the appellant, but did not, even in passing, comment on the inconsistencies in the prosecution's case, thereby reinforcing the belief held by defense that the court shifted the burden of proof on the appellant, which is contrary to law. Did this posturing of the Honorable Trial Judge lead to a substantial miscarriage of justice as defined in Chachu's case? Then he concluded, all these breaches complained of by the appellant put together, in my respected view, cumulatively affected the kind of sentence that was imposed on the appellant by the circuit courts. So this is a judge.
So he's saying,
yes,
it affected the sentence.
Yes.
It does not negate
Yes.
the conviction.
Yes. That is the explanation.
So further appeal, what were you going to do?
That is, no, you see, the point is this. As Daniel said, rightly said, in a trial, it is premised on the charge sheet. So in the specific circumstance of this case, the charge sheet was withdrawn. So it's not as if it was a minor error. In fact, prosecution kept shifting their case. At the start of the case, they made us believe that Agradaa was engaged in money doubling. The complainant scheme, questions were put to them. They denied that. The charge sheet is amended. They came back. They told us that the whole criminal enterprise happened under the coverage of Light-Off. They were challenged. They went back, changed it again. You see, so if a charge sheet is amended and withdrawn, it means whatever has transpired came on its knees. And the circuit court judge made a very worrying statement that she acquitted and discharged our client on Count 4 and Count 5. And the reason why she acquitted and discharged her was because no evidence was led. And Daniel will agree with me that in a criminal trial, you don't call an accused person to open a defense when no evidence has been led. So at what point, what did you see that got you invite us to open our defense?
But that claim of yours as a ground,
yes,
the judge in the court of the High Court,
yes,
also struck down because he said,
yes,
actually,
yes,
prima facie was made.
No, that was
so your invitation, your complaint that the invitation for you to open your case was wrong. It's not wrong. No, it's not founded.
No, he analyzed it as though we were arguing in context of Count 1, Count 2, and Count 3. Our concern is in respect of Count 4 and Count 5, where you have invited us to open our defense. And at the end of the day, you have acquitted us. And the reason for your acquittal is that no evidence was led. It's not us saying, it's the judge stating in a judgment that I've acquitted and discharged you on Count 4 and Count 5.
You made a submission of no case.
It wasn't done by the lawyer then, but an appeal was made against that.
Correct.
You see, so the point is that at the point that the trial judge invited us to open our defense in respect of Count 4 and Count 5, what was the basis? Because eventually you have acquitted her on those counts. And the reason was that no evidence was led. So it's not us saying a prima facie case was established, but it's the judge saying that.
Right.
And we believe that.
Okay, let me go back to Daniel. So it is very obvious, and Gertrude feels vindicated. We can't discuss legal education bill.
We have to. I told you.
This is how I force you to come back here. Because she's teaching, it's important to get the views of teachers of the law schools or law faculties about some of these things. And we'll reconstitute the panel for that. Yes, so Daniel, what do you have to say in your closing statement? Hello, Daniel. Please unmute your mic. We can't hear you. We don't know what the problem is, but we can't hear you. All right. Okay, so we normally will open the phone lines. It looks like time has run out on us, but we can try and see if we can pick one or two calls if you have been educated, and this is what I'm going to do, Daniel is coming back. He will recast the basis on which you can go to a court and say, I have been convicted and sentenced to this number of years. I want only the sentence to be reduced. What can you do? We want you to go with that education, even though they have done it collectively as they started speaking. Yeah, so you can call us. We can pick about 2 calls about what is going on now. All right, so whilst we try to get Daniel, any one of you want to say that as way of recasting an education to our audiences? What would be the occasion for you to go to a court and say, I've been given 15 years, I want it reduced?
Okay, so generally it's about the punishment prescribed and then the nature of the offense. And also, it's even a trial judge convicts a person. There's a pre-trial hearing, a pre-sentencing hearing. So if there are errors in those...
Joseph, you are calling us from Cape Coast. Let's hear you quickly.
Yes, so something. Thank you for the education. I will only believe with Attorney General that he should also go on appeal for that. Now it is 1-1. So looking at the discussion is that let us also go on a court of that way and ask whether it should be set as a second or
Okay, thank you. Your point is made. Who is next? Who is next on the line? Okay, pay attention. When you are calling, pay attention. You were canvassing a point.
Yes, I'm saying so. Sentencing, as Daniel said, is not, yes, it's at the discretion of the judge, but it is regulated also by law.
Correct.
And there is...
Gertrude said
yes,
so too.
And it is a hearing. The judge must consider both the aggravating factors and mitigating...
The extenuating circumstances.
So if there are errors in all those, and you believe the sentencing to is also harsh, that could be a ground for appeal.
All right. Gertrude.
Yeah, I think in addition to that is the case of the appellant. But what would the court consider in deciding whether or not to actually agree with the appellant?
Hold on. Akins, you are calling from a plow. Let's hear you.
Yeah, my question is that is demeanor and second punishment.
No. Get the education. Get the education, unless I didn't hear you right. So we have been educating on this platform over and again. The thresholds for the sentencing are this. There is misdemeanor. That's like a minor offense. The law says if the judge has to put you to jail, they shouldn't put you to jail for prison for more than 3 years. Then there is second-degree felony. Second-degree felony, it says where the law itself doesn't state the particular punishment, the number of years you should go, it should not be more than 10 years. But there are circumstances where for second degree, it goes to up to 25 years, like in this case. And there is also first degree felony, which can see you life imprisonment. Okay.
Okay.
You were making the point.
Yes, I was just making the point that from the courts, through quite a number of decisions, have told us what the appellate judge can also consider in deciding whether or not to. I can just go through one. This is the locus classicus from like Kwashi and the Republic. In fact, when you look at Frimpong alias Iboman, these were the same factors that the court looked at to reduce, I think, an almost 70-year sentence to about 30 years. The intrinsic seriousness of the offense, okay? The degree of revulsion felt by law-abiding citizens of the society for that particular crime, right? The premeditation with which the criminal plan was executed. The prevalence of the crime within the particular locality. The sudden increase in the incidence of the particular crime, and then the mitigating or the aggravating circumstances. So from the point of view of the judge, even the appellate judge, these are some of the factors that he or she can also consider in deciding whether...
Now I understand better why you don't even want it to go for less than 3 years.
Oh, no.
Our last call, Ibrahim. Hello, Ibrahim from Alaji. Go ahead, quickly.
Yeah, so I think I agree with the who holds the view that the appellate judge should have taken up from where the misdemeanor stopped. And so
Is it me? I can't hear you correctly. I think we've had a problem with the lines. Let's ignore the lines for now. Thank you very much. And as you know, we had advertised that we were doing this, how did we even think that we'll have sufficient time? So this and the law school reform bill, which is coming in to scrap the entrance exams and other things. We will consider that next week on the show. Thank you very much. I think this is all time will allow us. Were you trying to say something else?
Oh, not in my
I wanted you to exhaust
no, I don't want to bring up. We have our own issues
Richard,
about.
Is there anything you want to say again? Okay. I think our time is up.
Oh,
my guest, Daniel. Oh. Daniel, we'll give you the last word. We'll give you the last word on teaching our audiences when they can approach a court and say, I want my sentence reduced. What will be the factors? Okay, so I think Gertrude and Richard have done justice to those circumstances. So thank you very much. Daniel Krang is partner at Adum Legal Consult. He's based in Siani, and he's an author of legal texts, numerous of them, over a dozen by my count so far. Gertrude Amoko Ama is lecturer UPSA Law School and senior associate, also the PA Law and Associate. And Richard Asaribafo is lawyer for Evangelist Patricia Siama Agradaa. He's the one who is in celebration mode now. And he's looking like a Zambian. All right, have a good afternoon. This has been The Law. It's your legal light. It is your help law. We hope we have educated you.